Join ForumIAS Academy, trusted by hundreds of toppers, including IAS Rank 1 Shruti Sharma.
Hello and welcome to ForumIAS. Today is 3rd May 2023 and these are all the articles that we are going to discuss today. Without much further ado, let us go to the first article of the day. It talks about Swachh Bharat Mission's ODF Plus rankings. In that ranking, Wayanad district scores the top place. So it says that Kerala's Wayanad has become the first district in the country to be declared ODF Plus. So this district became the first and it is in the 3-star category. So basically in the ODF Plus there is star rating and under the Wayanad is in 3-star category. However, it is the first district in the country to be declared ODF Plus. Alright, so now we will see what is this ODF Plus. ODF Plus, simply expanded, it means Open Defecation Free Plus. It is a protocol under Swachh Bharat Mission Phase 2. So the Swachh Bharat Mission is executed by which ministry? Earlier it used to be Ministry of Drinking Water and Sanitation. Now this Swachh Bharat Mission is being implemented by Ministry of Jal Shakti. Okay, so this is the ministry in charge for implementing Swachh Bharat Mission Phase 2. Alright, so how to declare a particular village as a ODF plus village? So the same criteria they apply to district as well. So it says that they have to sustain the ODF status. First of all, there should not be any open defecation. Second, there should be solid as well as liquid waste management. And thirdly, it must be visually clean. If it satisfies all the three conditions, then only the particular village or a district can be called as a ODF plus village or district. So basically, before attaining all these three conditions, there will be a step-by-step process. That is, first they will become ODF plus aspiring, then they will do some more changes and then they will go to rising status and then they will go to model. Once they come to the model status, then they can be declared as ODF plus. So the first stage, that is, all the households should have a functional toilet. All schools or Anganwadi centers, Panchayat Ghar, they should have a functional toilet and they should have male and female toilets separately. And the village should have either solid waste management or liquid waste management. Either of these must be there for that particular village should be declared in aspiring category. Then all these conditions will come in the rising category also. But here if you see, it can have either solid waste or liquid waste. But in the rising category if you see, they should have solid waste management as well as liquid waste management. Otherwise, all the other conditions for possession of toilets, they are the same as the aspiring category. Alright. Next is the ODF plus model category. So this model category, it will have all the conditions from the rising category plus some extra conditions. That is, all the public places. So these are all the conditions with respect to toilets. It is the same. Then they should have solid waste, liquid waste management. We saw in the rising category itself. Now the extra in the model category is the public places should have minimal litter, minimal stagnant wastewater and no plastic waste dump in public places. And also they should have ODF plus IEC messages. What is IEC? information, education, communication. So that is the IEC messages. So IEC is a method of creating awareness through information, education and communication. We create awareness. So in the ODF plus model category, they should have public toilets as well as private toilets. They should have solid waste and liquid waste management. Public places should have minimal litter, and that particular village or district should have these kind of awareness messages in wall paintings or billboards. So this is how a particular village or a district declared as ODF plus model. Then they become ODF plus village or district. Next article. In this article, Union Minister Kiran Rijiju talks about the languages used in the state's codes. So, he is saying that regional languages should be used in courts in every state. So, 5 state high courts have started using Hindi as the court language, and now we have instant transcription and translation technology. So, all the states can use regional languages in the state high courts. That is what the minister is proposing. Now, we have to see the legal and constitutional provisions with respect to this. That this is very, very important for prelims. Okay, so unless the parliament provides otherwise, the following will be in English language only. That is, all the proceedings in the Supreme Court and every High Court, and also the authoritative text of bills, acts, ordinances, orders, rules, regulations, bylaws at the center as well as state level. So, the judicial proceedings will also be in English in center and state level. The bills, the laws, everything, the legal documents, they also will be in English language in the central as well as state levels. But the governor of the state, with the previous consent of the president, can authorize the use of Hindi or any other official language of the state in the proceedings of the High Court, but not with respect to judgments, decrees, orders passed by it. So, essentially, the governor can declare with the permission of the president that a regional language, that is the official language, any of the official language of the state, that is, one state can have many official languages. For example, the state of Bihar has official language of Urdu as well as Hindi. So, any other official language can also be declared as the language in the proceedings of the High Court. But whatever documents that are provided, they should be in English language. That is, the judgments, decrees and other orders, they must continue to be in English only until Parliament otherwise provides. So, the Parliament has provided through the Official Languages Act. So, you have to read this point in conjunction with this point. So, Official Language Act, what it says, it enables the governor of the state with the previous consent of president to authorize the use of Hindi or any other official language of the state for judgments, decrees and orders passed by the High Court, but they should be accompanied by an English translation. So, the Constitution itself says that the governor can declare that any official language be used in the state high court. But this is with respect to only the proceedings, not with respect to the documents. With respect to the documents, a law, that is the Official Languages Act, it is a law that provides the procedure through which the legal documents can also be in the official language. So, if I have to summarize this for you in a tabular column, so we have the proceedings. Okay, and we have the documents, legal documents. Okay, so proceedings, it can be in official language and that is declared using the provision in the constitution. But with respect to the legal document, it can be in the official language of the state. This is declared through the provisions of a law. Okay, so that is what it means in these 2 points. Okay, so there is also another point. A state legislature can prescribe the use of any language other than English with respect to bills, acts, ordinances, orders, rules, regulations, or bylaws, but a translation should be provided in English language. Okay, so basically the laws as well as proceedings of the court, they will be in English. All right, but the governor can declare with the permission of the president that the proceedings of a high court can be carried out in an official language of the state, but the laws, whatever the decree or judgments, they should be in English only. But official languages act says that the governor can declare with the permission of the president that the orders, the judgments, they also can be passed in the official language, but they must be accompanied by English translation. So this is the summary. The entire thing in this slide is summarized in this particular tabular column. Alright, then Hindi is used in Uttar Pradesh, Madhya Pradesh, Bihar, Rajasthan. So totally in these states, Hindi is used in the courts. Okay, the minister, he had said that some high courts have started using Hindi as the court language. Which are the high courts? They are the Uttar Pradesh High Court, Madhya Pradesh High Court, Bihar High Court, Rajasthan High Court. All these high courts have started using Hindi for the purpose. Okay, this might be asked in prelims. The next article is about de-dollarization, the race to attain the status of global reserve currency. Okay, first, what is de-dollarization? De-dollarization is the replacement of US dollar by other countries as the global reserve currency. Currently, US dollar is the reserve currency. To replace it, that process is called as de-dollarization. Now, what is a reserve currency? A currency that is used in cross-border transactions, that is in bilateral as well as multilateral trade. Then these are all the cross-border transactions. Typically, the currency that is used for bilateral, multilateral trade is US dollar and is commonly held as reserves by the central banks. Even RBI holds foreign exchange reserves in the form of dollars. Many countries have dollar reserves. So, what is a reserve currency? The currency that is used for transactions and the currency that is held as reserves. That is the reserve currency. At present, dollar is the reserve currency, but some countries are trying to replace dollar as the reserve currency. Why? Because of the Russia-Ukraine conflict. What happened was US placed sanctions on Russia. So anybody who trades with Russia, earlier they used to pay in dollars only. Now they can't pay in dollar because US has placed sanctions on Russia. And some are saying that this is the weaponization of dollar. Now, what does it mean? It means that US is trying to punish Russia by making dollar as a weapon. It can't use dollar, US dollar at all. So, this is called as weaponization of dollar. Simply speaking, by not allowing Russia the facilities to use dollar for its bilateral, multilateral trade, US is punishing Russia. That is called as weaponization of dollar. These days, because of the size of Chinese economy, Chinese yuan is seen as an alternative to dollar, but this has not gone forward. Till now, dollar is reigning supreme. So, if a currency becomes a reserve currency, what are the benefits? There must be some rhyme or reason behind why countries want to replace dollar, right? So basically, which country's currency will be used as reserve currency? At that point in time, whichever country is an economic superpower, their currency will be used as reserve currency. Now US is the economic superpower, so their currency is being used as the reserve currency. But if the economic clout of this country is waning, that means reducing, the currency also loses the status of reserve currency gradually. Earlier, the British pound, it used to be reserve currency, but after decolonization, as the economic might of the UK or the British Empire reduced, the pound, British pound, it also slowly stopped becoming the reserve currency. So this British pound is a very good example of a currency that underwent a downfall. But when a country's fiat currency is the currency banked by the fiat currency is the currency that is backed by a central bank. So in case of India, the reserve currency, the fiat currency is the rupee, and rupee is backed by RBI. So in case of dollars, fiat currency is dollar and it is backed by US Fed. You must have studied what is fiat currency in your static part. So when a country's fiat currency enjoys reserve currency status, they can print more currency, right? It is their currency, their central bank. If it is US, the US Fed can print as many currencies as they want, and they can use that currency to buy goods and services from the rest of the world. But that is an undue benefit to a country whose currency is the reserve currency for international trade. However, if the US Fed, if they keep on printing dollars, then there will be something called as debasement of dollar. So, debasement will happen. If the US Fed is expanding the economy by printing more money without any rhyme or reason, just so that it can buy goods and services from the world, this is called as irresponsible expansion of money supply. And this leads to debasement, and debasement means loss in value. The value of the dollars will go down if the US Fed is printing more and more dollars just so that it can buy goods and services from the rest of the world. Then there would be too much dollars. The value of dollar will reduce. So that is called as debasement. When this happens, this currency itself will lose the reserve currency status, right? So again, the country which has its own fiat currency as the reserve currency, they won't do anything like this. They won't do any irresponsible expansion of money supply, because they will lose the reserve currency status, which they don't want to happen. So that is a check and balance that is inbuilt. Okay. So some people are saying that US Federal Reserve, that is US's central bank, they have been following an expansionary monetary policy. Expansionary policy means printing more currency in simple terms. Then US dollar status as reserve currency, would it not be threatened? Would it not be threatened? This is a valid question, right? When reading this article, you might also have the question, but I have read in the newspaper that US has been following expansionary monetary policy for many years. Then there are too much dollars in the supply. Then wouldn't the value of US dollars reduce? And by default, the US dollar might lose its status as reserve currency, right? It might happen. Why doesn't it happen? Why didn't it happen? Because other countries also, they had an expansionary monetary policy. So not only US but other countries also had an expansionary monetary policy. So as a result, as long as the US does not debase its currency at a faster pace than other countries, then the dollar may manage to hold its value against other currencies. So, say for example, we take US dollars and Japanese yen. Okay. So, in this case, what happens? The US Federal Reserve, they are also following an expansionary policy. So, the amount of dollars are increasing. In this case, what will happen? Dollar value will reduce, right? But this is not happening. Dollar is also increasing. Similarly, other countries' central banks, they are also printing more currency. The value of dollar remains the same because we have equal amount of Japanese yen that is chasing the US dollars. This is not the case. If this has been the case, then what will happen? The value of US dollar would have reduced. Instead, this is the case. Why? Because not only US, other countries are also following an expansionary monetary policy. So the value of dollar has remained intact. That is why it is retaining its status as global reserve currency. So, is there no solution to it? Can anybody stand up to the US hegemony in this case? It was tried in India-Russia relations. So basically what happened was, in India-Russia trade, we decided that we will hereafter use rupee. Okay, whatever oil that we are importing from Russia, whatever weapons that we are importing from Russia, we have decided with bilaterally with Russia that we will pay for that in rupee. Okay, but this hit a roadblock. Why? Because India's imports from Russia are more than India's exports to Russia. So that means India is buying more from Russia than what it is selling to Russia. Okay, so what happens? Russia has excess rupees because India is buying more. So it will buy goods or services and it will give more money to Russia. So Russia had excess rupee and Russia wasn't willing to spend it on Indian assets. If Russia had excess rupees, if they are doing an FDI or FPI in India, then they will use the rupee. But they are not willing to spend on Indian assets, then they are left with excess rupee. With which what will they do with that excess rupee? Right? They should again convert it into dollar. Why would they go through that pain? So Russia said, no, you settle in US dollar itself. We don't want your rupee. Even Russia, which is considered to be an all-weather friend of India, even they said no to our Indian rupee. So, why this is so? Why does even Russia want US dollars? Because there is global acceptance of US dollars. Why there is global acceptance of US dollars? Popularity of US assets among investors. Now, this is explained in the next sentence. That is, US as a country, it has a large trade deficit with most of the countries. Okay, which means US is buying more from the world. Buying more. Okay, it is buying more from the rest of the world. So the rest of the world will have dollar surplus. If US is having trade deficit, then the other countries will have trade surplus with respect to US. Even India has trade surplus with respect to US. So what will India do with the excess dollars? India stores it in the form of reserve currency and that dollar is used to invest in US assets. So take it for any country with the excess of dollars, it in turn comes back to the US in the form of investments in the US assets, in the financial assets. That is why dollar is more popular, because the other countries, they have faith in the financial stability of US. They want to gain from the financial assets of the US. That is why US dollar is more acceptable. Unless and until another currency reaches this status, US will remain as the global reserve currency. Okay. Now, the next article, it is about center planning to find an alternative to death by hanging. So, at present, section 354 clause 5 of the Code of Criminal Procedure says that a person sentenced to death shall be hanged by the neck till he is dead. This means that till the person is dead, the person will be repeatedly hanged. By hearing this itself, we understand that this is a very cruel procedure, right? That is why the law is challenged. This section 354 clause 5 of the Criminal Procedure Code is challenged. So, the government apprised the Supreme Court on Tuesday that it is considering the formation of a committee to examine the need for a painless and more dignified alternative to death by hanging. Now, they are talking about a dignified death. Dignified death. So, we have Article 21, right? Article 21 of the Indian Constitution, it talks about right to life and liberty. Right to life and liberty. We know this, right? So, this life, it is not mere vegetative existence. This life should be a dignified life. The converse of this is dignified death. There should be dignity in death. Nobody deserves to die in a cruel way, in a debased manner. If they have led a dignified life, they should also have a dignified death. This is under the provisions of Article 21. Article 21 just talks about right to life and liberty. But an in-depth reading of this article will make us understand that it also talks about dignified death. This word is not given in the Constitution. This is our understanding based on various jurisprudence, various case laws. Now, this dignified death, it was given by Supreme Court in the Common Cause versus Union of India. In this case, the right to dignified death was exemplified by the Supreme Court. The court had indicated to the center that it may even direct an alternative method of executing capital punishment if it was proved that there was a more humane method of execution which would render death by hanging unconstitutional. If there is any other method which is more humane than death by hanging, then death by hanging would not be a dignified death. So then automatically it would become unconstitutional and another method would be put in place. So for that, the Supreme Court has asked for evidence from the center, for which the center is forming a committee who will read up and who will make a report on this to the Supreme Court. Impact of the sentence of death by hanging, the pain caused, the period of actual death, availability of resources for hanging a person, all these things would be studied by the committee and they would present the report, and based on that, the Supreme Court would take a decision. Now, we will see the background information which is relevant for prelims. Alright. So, we already saw that right to dignified death is talked about in the case Common Cause versus Union of India. And also, holding capital punishment cases for long period without execution, it is a mental torture because you could have studied pardoning power of president in your static part. In that, there is this particular pardon, that is reprieve, which is a stay of execution of a sentence for a temporary period. Okay. So, in this case of reprieve, there is the stay of execution. So, this person is essentially not being executed and they are awaiting a death sentence. That is considered as a mental torture to the prisoners. And moreover, India is yet to ratify the UN Convention Against Torture. So this is a form of mental torture. Though India has not ratified, this is one point to consider. And if there is a more humane way of execution, probably the mercy petition that is received by the president under Article 72 of the Constitution, it might also reduce. Now we have to see Article 72 from prelims perspective. So it empowers the president to grant pardons to persons who were tried under the punishment or sentences for an offence against union law, the punishment or sentence is by a court martial, and death sentence. A death sentence can be pardoned only by the president. The governor of a state cannot pardon a death sentence. Okay. So, what are the pardoning powers of the president? The first one is pardon. That is, it removes both the sentence as well as the conviction and completely absolves. Completely absolves means they are free. They are let go. They are free. They are let go from everything. From conviction as well as sentence. That they are totally let go. That is pardon. Second is commutation. Commutation is where there is a substitution of one form of punishment for a lighter form. That is, a death sentence can be commuted to a rigorous imprisonment. That is, compared to death sentence, rigorous imprisonment is a lighter form of punishment. So, commutation is conversion of a harsher punishment to a less harsher punishment. That is commutation. Next is remission. So, here we have remission. So, remission is reducing the period of sentence. That is, if there is a rigorous imprisonment for 2 years, then it can be remitted to rigorous imprisonment for 1 year. The nature of the punishment is same in both cases, only the time varies. It has changed from 2 years to 1 year. Next is respite. Respite is awarding a lesser sentence because of some special fact. Like the person is having some disability or the convict is a pregnant woman. In that case, there is a lesser sentence in place of a originally awarded sentence due to special fact. Respite is for a special fact. Reprieve we already saw, which is a stay in the execution. Why stay the execution? It will enable the person to have time to seek pardon or commutation from the president. So, based on this article, Article 72 is the background information which is important for prelims. We have discussed this Article 72 in its entirety. Okay, finally the last article of the day, it talks about Karnataka being ranked the most innovative state in manufacturing. In which ranking? Where it has secured the first place in the National Manufacturing Innovation Survey. It is a joint study conducted by Department of Science and Technology and United Nations Industrial Development Organization. National Manufacturing and Innovation Survey conducted by DST and UNIDO. So, they conducted this, and the degree of innovation among manufacturing firms found that Karnataka overall is the most innovative state, followed by Dadra and Nagar Haveli, Daman and Diu. It is one single union territory. These two have been combined. Then third place is Telangana, fourth place is Tamil Nadu. And in the bottom, these states are there. Odisha, Bihar, Jharkhand. They have the lowest share of innovative firms. So, in these particular states, what stops innovation? What are the barriers to innovation? That is, lack of funds. The cost of innovation is very high and lack of financing from external sources. The main thing that is stopping innovation is money. whether it is internal funds or external funding. Money is an important factor that is preventing many firms from innovating. Okay, just remember who conducted this, that's all, and which state is first. This is enough for your prelims purpose. Now we will discuss some previous year question. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. 2. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India, which is correct. So let us see the first statement. High Court, it says that High Court does not have the jurisdiction to declare any central law to be constitutionally invalid. This is wrong. Because India has an integrated judiciary. Integrated judiciary. What does this mean? Integrated judiciary means there is a single system. The Supreme Court, under that there will be High Court, they all implement all the laws. It is not that Supreme Court will take care of central laws, High Court will take care of the state laws. It's not the case. Together, this integrated judiciary will take care of center as well as state laws. Okay, this is different in US. The US Supreme Court will deal only with the central laws and the provincial courts will take care of only the state laws. That is the case in judiciary of US. But in India, we have an integrated judiciary in which the single system, they will cater to both center as well as state laws. So, the first statement is wrong. Amendment of Constitution of India cannot be called into question. This is wrong. Even the constitutional amendment cannot breach the basic structure of the Constitution. So, both the statements are incorrect. It is asking for correct statement. Answer is D, neither one nor two. Next. Purchasing power parity exchange rates are calculated by comparing the price of the same basket of goods and services in different countries. In terms of PPP dollars, India is the 6th largest economy in the world, which is correct. Yes, purchasing power parity exchange rate. See, we have nominal exchange rate. Today, if you go and do a Google search or if you see in the newspaper, it will say that $1 is equal to 70 rupees. Okay. This is nominal exchange rate. Nominal exchange rate. But can $1 buy the same things as 70 rupees? Say for example, let us take the case of masala dosa. Okay, in India, probably we can buy 2 masala dosas with 70 rupees. But in US, you can't buy even half a masala dosa for $1. Probably you might be able to buy 1 masala dosa for $2. So then this nominal exchange rate is not holding good because the value of $1 and 70 rupees are not the same. Wherein 70 rupees you can buy 2 masala dosas, but for $1 you can buy only half a masala dosa. So now we are comparing the value of masala dosa in both US and India, and if we compare that, that is comparison in terms of purchasing power parity. Whether the same $1 has parity with 70 rupees in terms of its purchasing power. That is comparison of purchasing power parity. So if we compare that $1 is equal to half masala dosa, right? So then what will be the real exchange rate? Let us do a little mathematics now. What will be the exchange rate? So in order to buy the same thing, that is for $70 you will get 2 masala dosas. $4 is equal to 70 rupees. This is the in terms of PPP terms. This is the nominal exchange rate. This is the real exchange rate. Okay. This is a simplified example. We are taking only masala dosa. Now, if we are comparing a basket of goods, generally this is oversimplified version. That this is just for your understanding. Okay. So, when we are really calculating the real exchange rate, there is a basket of goods. It's not just masala dosa. They will compare pen, pencil, machines, computer, everything. Okay, so that is about PPP. So this sentence says that purchasing power parity exchange rates are calculated by comparing the prices of the same basket of goods and services in different countries. That is correct. In PPP terms, India is the sixth largest. This is wrong. In PPP terms, India is the third largest economy. So which one is correct? Answer is A, one only. Last question. Among the agricultural commodities imported by India, which one of the following accounts for the highest imports in terms of value in the last 5 years? A. Spices, B. Fresh fruits, C. Pulses, D. Vegetable oils. Answer is vegetable oils. Why? Because 60% this year's economic survey, that is economic survey 2022-23, it says that 60% of all our vegetable oils are imported. That shows how much we are importing. So, the number one agricultural commodity that is imported is vegetable oil. Okay, that's it for today's discussion. Follow us on all the social media channels. This is Indumati signing off. Thank you. Bye-bye. All the best.